Okay, sir. Good evening, everyone. Firstly, I would like to extend a very warm welcome to the esteemed resource person, Mr. Ankit Kaushik, and obviously our backbone of this event, Dr. Kalpesh Kumar Gupta, sir. It is my pleasure and privilege to introduce our esteemed guest today, Mr. Ankit Kaushik. Mr. Kaushik is currently serving as an assistant professor at the prestigious National Law University, Delhi, where he specializes in legal research and criminal law. He holds a BA LLB honors from the National Law University, Jodhpur, and pursued his LLM in criminal law and constitutional law from NLU, Delhi. His academic journey has been complemented by significant professional contributions, including his previous role as an assistant professor at RGNUL, Punjab, and as a research associate at the Center for Criminology and Victimology at NLU Delhi. Mr. Kaushik has been at the forefront of several important empirical research projects, particularly in the areas of crime against women and juvenile justice. His policy work includes meaningful contributions to national discussions on radicalization and de-radicalization with the National Investigation Agency and the Bureau of Police Research and Development. His efforts in community policing have been recognized with the Director General's Commendation Certificate. He also serves as the executive editor of the Journal of Victimology and Victim Justice, further demonstrating his deep commitment to the legal scholarship and justice reform. His session today shall be on the topic human rights and rights of the victims or rights of the vulnerable. We are truly honored to have with you here today, sir. So I would like to give it to you for continuing with the session.
Okay. A very good evening to all, and thank you so much for that very kind introduction. At the outset, I would also like to thank Professor Kalpeshwar Gupta for inviting me to this 10-day online capacity building program on ADR and legal aid and allied laws, which has been jointly organized by the JSS Law College and Pro Bono India. It's always a pleasure for me to give my 2 cents at Pro Bono lectures. And for today, the topic that I'll be speaking on, as she's already introduced, is human rights and rights of the victims and rights of the vulnerable. So the basic idea behind the presentation today, I hope the presentation is visible to all. Yeah. Okay, perfect. Right. So the basic idea, and let me just give you a brief TOC or the table of contents with respect to what the presentation today is going to look like. Given that we'll be dealing with mostly law students, and I know for a fact that given that we come from a very traditional paradigm of criminal law, it becomes very tough for us to locate the victim in the criminal justice system itself. I'm going to be beginning with that idea, right? And I'm going to be traversing 3 very important fields. The first field that I'm going to be traversing is that of what the what victim rights should look like within the criminal justice system. That is the normative aspects. What do the criminal, what rights does the victim actually have in our criminal justice system? That is the positive aspect. And lastly, we are also going to be looking at does our criminal justice system actually have the potential to capture this entire, this wide landscape of rights that are emerging today across the world with respect to victims and specifically with respect to vulnerable victims. So the thing is that this topic, it gains importance because in most law schools, the focal point of all courses relating to human rights in terms of criminal justice, they're largely geared towards developing an understanding of criminal justice, towards developing or understanding the nuances of criminal law, and primarily focused at what are the duties of the state and what are the rights of the accused. Nevertheless, amongst the various critiques of criminal laws that are emerging today, and there are many critiques, right? You can have socio-political critiques, you can have historical critiques, you can have functional critiques, you can have dialogical critique. But one of the most important critiques of criminal law that is emerging today is the victimological critique of criminal law, right? And this lecture will basically try and examine how, how inputs from the field of victimology can actually translate into an actualization of victim justice through the recognition, through the identification and the enforcement of victim rights themselves. So as far back as 1980, you had the Indian Supreme Court in the Maruram case coming out and saying the statement that is on your screen right now, that victimology, it must find fulfillment. It's a upcoming branch of criminal justice, and it must find fulfillment by also looking at the restoration or the reparation of the damage that the offender has done to the victims. Um, and this can be done not only in terms of punishing the offender, but because, at the end of the day, the question always remains like, what does the punishment do for the victims of crime? Um, Apart from that mental satisfaction that yes, justice of one kind has been served, there are so many other aspects of justice that remain, and including something that's very pertinent to this particular course on ADR, restorative justice, right? Because restorative justice, by their very nature and dimension, they have to take into account alternate dispute resolution practices. Because restorative justice is not something that has been institutionalized in our laws yet. It's not something that has been formalized in our laws yet. So there's a need for us to also think about, giving the victims a place in our criminal justice system. Now, victimology tells us that there are two primary kinds of victimizations. The first is primary victimization, and the second is secondary victimization, right? Primary victimization is something that's very easily understood. It's the primary impact of the crime upon the victim. So if somebody slaps you right now at this very moment, right? Uh, the fact is that you're going to suffer not just one kind of injury, but you're going to suffer many different kinds of injuries. The first kind of injury you're going to suffer is obviously physical, right? Somebody has slapped you in the face. So you're going to feel the immediate pain of that slap. But the other kind of injury that you're also going to suffer at the same time is that um, that there is always that aspect of humiliation in a slap as well, right? The fact is that if somebody slaps you right now, your ego is going to be just as bruised, if not more, than your face, right? So there is a mental aspect, there is a psychological aspect with respect to, the psychological impact of the crime upon you as well. Now, depending upon your upon the context itself, your reputation might end up suffering as well. For example, imagine that you're sitting in a cafeteria and all your friends are with you, and that's the point when somebody comes up to you and slaps you, right? That will not just hurt you psychologically in the sense that my right has been violated. My physical space, the sanctity of my physical space has been violated. But at the same time, you're also going to feel that this has not happened in private. This has happened in public. Everyone has looked at me getting slapped. So there's an element of reputation that comes to be involved as well, right? So these are all examples of primary kinds of victimizations, right? And this much is recognized by criminal law as well, right? For instance, Section 44 of the Indian Penal Code, it used to list out that you can have four kinds of injuries. You can have injury which is can be to the mind, injury that can be to the body, injury that can be to property, and injury can also be to reputation, right? So this kind of injury, the private, like primary victimization, it's something that criminal law seems to recognize very easily, right? Um, but the fact is that whenever the questions of how are now we now going to fix this primary injury that's happened to me, um, the only recourse that you have is to the state, right? So if somebody assaults you, what is the first thing that you do? Um, the fact is that if you follow the social contract theory, which might seem theoretical but at the same time does have practical implications, the idea is that you have given up your right um, to retaliate. You have given up your right to take revenge onto the state or to the leviathan, and that the leviathan is now going to be taking the actions on your behalf, right? So you do not have any right if somebody assaults you right now, unless and until you are retaliating in self-defense, you do not have a right to retaliate. So the basic idea is that the only thing that a victim can do in such situations is to approach the state. And the first thing that you do if you're going to get slapped is to go to the police, right? They're your recourse, they're your immediate recourse, they're the first point of contact that you have to the state. But the fact is that the moment you as a victim approach the state, you as a victim approach the police, uh, it's the state that's going to take over your role as a victim, right? Um, all modern readings of criminal law, all modern readings of criminology, criminal justice, they tell us that the state essentially has appropriated the role of the victim in the criminal justice system. And it remains a fact today that state steps into the shoes of the victim and in turn governs the relationship that the victim has to that conflict, right? It is the state which investigates the offense. It is the state which decides whether we should be prosecuting the offender or not. Um, it is the state which determines which evidences are worth producing in court and which evidences are not worth producing in court. It is the state which ultimately decides and determines that after a person has been convicted by a court and he has been sentenced to punishment, should he be released on a probation of good conduct, or whether he should be given remission, or if his sentences should be commuted. All of these decisions are being taken by the state, and very few, if any at all, decisions take into account the autonomy of the victim. Very few of these decisions actually take into account what the victim wants. Um, what do they, ultimately desire should be an outcome of this entire process, or should be their role in this entire criminal process, right? So the question that we need to ask ourselves simply is that, does the victim have a say um, in this criminal process, criminal justice process? And if so, then what is the extent of this say? And what recourse does the victim have if the system fails, and fails to address their concerns? And what can you, like by you I mean you, right? As future legal luminaries, as future lawyers, future judges, future academics, future activists, what can you do to ensure that victims do not suffer from secondary victimization, right? So the basic idea here is that with respect to secondary victimization, this kind of victimization, as opposed to primary victimization, secondary victimization occurs when the victims are unable to get their due. And it occurs when the state decides that victims are essentially voiceless subjects, um, in our criminal processes. So when a victim of rape goes to the police station but is unable to register a complaint due to, let's say, jurisdictional issues, or that itself is secondary victimization, or when the victim does not get medical attention on time because the doctors require some kind of legal formalities to be completed before the victim can get medical treatment, um, that is a form of secondary victimization, right? So these are emerging from legal processes, these are emerging from the criminal procedure itself, and that is what is victimizing the and also the society as well. But the society, but society in the sense that as much as society impacts the functionaries of our criminal justice system, right? So functionaries of our criminal justice system, they don't operate in isolation. They don't stop being members of the society. So functionaries of our criminal justice system are going to be equally colored by the society's perceptions, as you and me, right? For that matter. So, I mean, all of this, wherever there are structural inequities that prevent a victim from getting their due, that is called secondary victimization, right? And it is this discourse, this entire discourse, that took me about 14 minutes to cover. It is this discourse that requires us to move beyond the understanding that a criminal trial is just a two-way process, that is just a conversation between two parties, the offender and the state. Instead, we need to locate the victims in our criminal process. And the best way for us to do that is to give due recognition to the victims of to the rights that the victims have. And when I use the term victim here, I must add a caveat that I'm talking about victims in a very general sense, right? I'm not talking about victims of specific crimes. I'm not talking very specifically about rape victims or atrocity victims. I'm talking about, victims in general, victims as to how they find a place in our criminal justice system in general, right? So, of course, I mean, I'm not saying that like victims who of specific offenses do not require specific treatments. They do. But at the same time, there must be certain generalizations, right? There must be certain general rights that must be made available to all victims of crime, regardless of their status as victims of specific offenses, right? Um, so, keeping this in mind, the first area and the first landscape that we're going to traverse is that of the normative requirements. That is, what ought to be the state of human rights in terms of rights of the victims, very specifically and very, very specifically. So, with respect to this, there is a declaration, a UN declaration to which India is also a signatory. Um, and the name of this declaration is the Basic Principles for Justice to Victims of Crimes and Abuse of Power. And this was signed all the way back in 1985, right? So that's what, about 40 years ago, right? Roughly. And even to this date, the Declaration of Basic Principles essentially, um, it it is essentially, it represents the normative discourses that a domestic legislative framework must integrate within the criminal justice system in order to secure justice for victims of crimes, right? And primarily, it structures and classifies uh, four requirements that victims of crimes have. The first is with respect to access to justice and fair treatment. So this declaration primarily requires for the victim to be treated with compassion, to be treated with fairness and respect for their dignity. And towards this idea, it then creates an entitlement for the victims of crimes and abuse of power for accessing mechanisms to justice and providing, as have been provided by national legislations. This declaration obviously also requires for the establishment of judicial and administrative mechanisms, which enable a prompt redress of the harms that have been suffered by the victims. The victims are also required at the same time to be informed of their rights to access these redressal mechanisms. The fact is that unless and until a victim has information with respect to what their rights are, how are they supposed to access them? How are they supposed to know that they even exist in the first place? So, informational justice becomes very important. Information can include everything regarding their role and their scope within a trial, as well as information with respect to the timing and the progress of the trial and proceedings. This declaration also requires for legal assistance to be provided to the victims throughout the process, as well as a right to allow the views and the concerns of the victims to be presented. That is the right to be heard, right, and considered at all appropriate stages of the proceedings. And of course, this has to be done without any prejudice to the accused. Um, the state parties generally are required to minimize inconvenience to the victims, to protect their privacy, to provide them with security and safety from intimidation and retaliation by the accused or their families. They also, seek to avoid any kind of unnecessary delays in the disposition of cases. And they also encourage the use of informal mechanisms of dispute resolution. Um, this is again very pertinent to our cause, including mediation, arbitration, and customary justice or indigenous practices. Right. So in Australia, you've got something called harmony circles and sentencing circles. So you have restorative practices like this which can always be taken into account. And these are all community-based practices. Of course, we can't go into much detail with respect to this, given the time restrictions that we generally have. The second aspect of the second pillar rather of the rights of victims normatively is that of assistance. Um, So the declaration basically entitles victims to receive all kinds of necessary material, medical, psychological, and social assistance through governmental, voluntary, community-based, and indigenous sources. It also requires for the information regarding the availability of health and social services, and how to access these health and social services. The declaration requires for the police, justice, health, social service, and all of these personnel to be trained, to be sensitized towards the needs of the victims, and for creating guidelines for some kind of a prompt and proper aid, in general, right? So normatively, all of this is expected in terms of assistance from the criminal justice system. The next idea or the next pillar, is that of restitution. Broadly put, so restitution, generally means that reparations have to be made now from the offender to the accused. This differs from compensation, in the sense that compensation always flows from the state to the victims. So under this third pillar, this requires that offenders must make fair restitutions to the victims and their families, and these restitutions can include everything from return of their property to the payment for the harm or the loss that they have suffered, for the reimbursement of any expenses that have that they have incurred from victimization itself. So the primary harm, like I said, it can be of different types, right? You can have physical harm, you can have mental harm, you can have harm to your property, you can have harm to your reputation. But then you can also have damages which emerge out of these harms. Um, Financial expenditures that emerge out of these harms. For instance, the fact that because of some kind of a physical injury, you then have to go to the hospital. Then you had to pay for your own treatment, or because of some kind of a psychological injury, you had to go to a counselor, and you had to take up therapy, and that itself is going to cost you a lot. So all of these also have to be made good by the victims. Then there also has to be, the governments themselves, they are required to tailor whatever laws they have, um, to allow for restitution as a viable option for sentencing, in criminal cases, right? Um, I'll come to sentencing now, but generally the idea is that under our criminal justice system right now, we find that sentencing is something that is very, very rigid. A judge only has discretion to provide for the kinds of punishments that are provided for under the Bharatiya Nyaya Samhita or under any kind of a special or local law. They have very little discretion, very little, bandwidth and freedom, to award any kind of independent or creative ways to, give or creative ways to punish an offender such that reparations can also be made to the victims. Um, Apart from this, you also have compensation, and this is the fourth pillar. Like I said, restitution flows from the accused to the victim. Compensation, of course, then flows from the state to the victim. Compensation. This says that this declaration requires for the state to provide compensation to victims in the event that the restitution itself is not fully available from the offender. Financial compensation should be provided to the victims who have suffered significant bodily injury or impairment of their physical or mental health, or to the family of the persons who have died or become physically or mentally incapacitated. States should also encourage the establishment of national funds for compensation of victims, right? So this is broadly put. So these are the four pillars that we have. These are the four normative requirements that we have. We require the right to access to justice and the right to fair treatment. There is a right to assistance that a victim can expect from the state. There is a right to restitution, and there's also a right to compensation. So these are the four broad rights, that roughly emerge from the Declaration of Basic Principles for Justice to Victims of Crime and Abuse of Power. Now, having traced what the normative requirements of the victims, of victim justice, um, or rather what victim justice ought to be, in terms of the rights and entitlements of the victims, addressing the topic at hand requires us also to address what is of our criminal justice system, right? So the thing is that in the absence of any kind of comprehensive statutory or policy framework with respect to victim justice, India presents a very unconventional growth model, for the development of victim rights. And the spur has been primarily on judicial decisions, rather than legislative innovations, right? Very, very, if I want to put it very bluntly, right? Um, so again, let's see how India performs in terms of access to justice. Um, Despite the fact that the Declaration of Basic Principles for Justice to Victims of Crimes was signed all the way back in 1985, victims came to be recognized in the Indian jurisdiction only in the year 2009. One second, please. So victims came to be recognized in the Indian jurisdiction only in the year 2009 by the Criminal Law Amendment Act of 2009, which inserted a very deficient definition of victims vide Section 2AA in the Code of Criminal Procedure of 1973. This definition only applied to those cases where an accused could be apprehended and charged with an offense. So remember, like this is one of the core questions, in fact, in terms of trying to understand when does a victim become a victim, right? And to be more, direct, when does the criminal justice system actually recognize a victim? Does a victim become a victim the moment a crime is committed against them? And this is what victimology would tell us, right? Because there are so many cases where the victims don't even come forward and report that offense. So does that mean that they're not victims for the criminal justice system, or are they not, do they not deserve recognition as victims? Right? That's a very core question. That's a very crucial question. Or does a victim become a victim when they actually go and report an offense? When they tell the state that, look, I have been victimized, do they become a victim only then? Or do you want to filter this out even further? Because you can always have people who come out and file false cases, right? Um, so you want to make sure that at least uh, somebody who is, that only genuine cases are being treated as, as victims. So do you want that we should only recognize them at a stage when a charge sheet has been filed, right? And charges have been framed against such persons? Um, so when is it exactly do we when do we recognize a victim as a victim? Should it be at the stage of, let's say, also conviction? That it's only after a conviction has been secured that a victim becomes a victim. Otherwise, they're not victims. They might be lying, right? For instance. So this is a very crucial question. And what the Criminal Law Amendment Act of 2009 did was that it inserted Section 2AA in the CRPC. And the stage at which it granted recognition to victims of crimes was after the charges had been framed in this matter, right? Of course, there was a lot of criticism against this because at the end of the day, this is too late a stage for a victim to become a victim. Remember, it's contingent upon us recognizing a victim that all of their other rights then flow. Their right to be informed, for instance, of the investigation. But by the time you're recognizing a victim after the framing of charges has been done, um, the investigation has already been completed. So the victim was never recognized as a victim during the entire investigation, right? So of course there are criticisms that emerged with respect to this understanding of who is a victim under under Section 2AA of the CRPC of 1973, and ultimately it took us another 15 years to then fix this and bring in Section 3, subclause Y of the Bharatiya Nagrik Suraksha Samhita, which then defines the victim to mean a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes the guardian or legal heir of the victim. Right? So you've removed this requirement now. You've removed this requirement with respect to when does a victim become a victim in terms of, and the answer that the CRPC gave us, that a victim becomes a victim only at the stage of framing of charges. So that's not the case anymore. A victim today under the BNSS is being recognized as a victim regardless of whether or not they have actually approached the criminal justice system even, right? Of course, there are other problems with this definition, but let's not go into that at this moment. In any case, the criminal justice system that we have currently, it provides for access to justice in through two very important ways. The first way it does this is in the form of Section 173 of the Bharatiya Nagrik Suraksha Samhita, whereby, which is very simply, which we very colloquially understand as First Information Report, FIR, right? So you go to a police station and you register an FIR. right? What does that mean? That you're giving information to a police officer under Section 173 of the Bharatiya Nagrik Suraksha Samhita. So this is one of the very important ways in which the criminal, the victim actually goes ahead and triggers the criminal justice system in the first place. But what happens in case the police officer refuses to register an FIR? Of course, you can always go and complain to the superiors of the police officer, and mandatorily have to before you can actually approach and take the next step. But the other way in which the access to justice has been provided in our criminal justice system is through Section 210 of the Bharatiya Nagrik Suraksha Samhita, where the victim can directly approach the judicial magistrate by giving an affidavit that they went to the police refused to register an FIR, they went to the superior officer, but they haven't received any word, and therefore we are coming to you directly. And now please register my complaint. So you give them a complaint, and then that becomes a complaint case. This has a completely different procedure under the criminal justice system. So you've got two very important ways in which the victim triggers the criminal justice system itself, right? Um, Often, however, as opposed to a blanket recognition of a right, certain rights relating to access to justice and fair treatment have been accorded in a very limited sense, right? So, access to justice, we understand. Of course, access to justice is important. That is being provided through Section 173 of the BNSS. That is being provided through Section 210 of the BNSS. However, um, what happens after that? What right does the victim had, for instance, to participate in a process, in a criminal process, right? And with respect to that, the only right that the victim has um, is to engage a private advocate, right? So this is a right which has been allowed to the victim under Section 18 subclause 8 of the Bharatiya Nagrik Suraksha Samhita. They have a right to engage a private advocate, but Section 18 clause 8 makes it clear that this private counsel that has been hired by the victim, their role is only to assist the public prosecutor, right? This understanding of the assistive role that the private counsel plays is further cemented through Section 338 of the Bharatiya Nagrik Suraksha Samhita, whereby the private counsel who has been engaged, they cannot actually conduct the prosecution themselves, but rather they act under the and I quote directions of the public prosecutor. Right. The only right that they actually have, these private advocates that has been hired by the victim, is then to file written submissions in the matter after the evidence is closed. So once the examination in chief is done, once the cross examination is done, and all evidences have been examined, everything has been done, all of these evidences have been closed. It's only then, at that stage, that the victim then has a right. The victim's advocate then gets a right to file written submissions, right? So his written submissions will then have no impact whatsoever in terms of examination in chief, in terms of appreciation of evidence, and in terms of cross examinations. And this entire procedure, that the very limited role that the victim's private advocate plays in our criminal justice system, this received a judicial stamp of approval by the Supreme Court in the case of Rekha Murarka versus State of West Bengal. And the statement that the Supreme Court made an observation is on your screen right now. They say that a victim's counsel should ordinarily not be given the right to make oral arguments or examine and cross-examine witnesses. As stated in Section 301 Clause 2, 301 Clause 2 is analogous to 338 of the BNSS. The private party's pleader is subject to the directions of the public prosecutor. In our considered opinion, the same principle should apply to the victim's counsel under the proviso to Section 24 subclause 8. 24 subclause 8 is analogous to Section 18 subclause 8 of the BNSS. As it feels adequately, as it adequately ensures that the interests of the victims are represented. If the victim's counsel feels that a certain aspect has gone unaddressed in the examination of the witnesses or the arguments advanced by the public prosecutor, he may then route any questions or points to the public prosecutor himself. Right? Um, so the idea here is that again, um, you know, the victim's private counsel has a very limited role to play in the criminal process itself. And the exemplification of this limited grant of rights to to the victims, it also extends to the jurisprudence on the right to be heard at appropriate stages of the proceedings. The fact is that, as stated earlier, the judicial trends have been the primary source of victim rights and entitlements in the Indian context. And there are very few cases, in fact, which provide or expand the role of victims within the criminal justice system. Um, like I said, the victims have a very limited scope to play at the time of investigation. And as above mentioned, and as the discourse on victims, private counsel goes on to show, the victims have very little participatory rights in the criminal process itself, as compared to the trial procedure that is available, for instance, under the ICC, that is the International Criminal Courts, where provisions have been made for the victims to be heard at every appropriate stage. No such blanket right has been made or accorded to the victims under the legislative framework that we have currently. Um, there is a right for us to file a protest petition, for instance, against the decision of the police to not file a charge sheet. That is to file a closure report. That is, they don't want to proceed with the investigation any further. They don't want to proceed with the case anymore. They want to file a closure report. So the only right that the victims have at this stage is to file a protest petition. And even this right is not something that is statutorily recognized. This is not a right that is provided anywhere in the Code of Criminal Procedure. This is a right that has, become the law by judicial decisions. Right? It's become a law through judicial precedents. Right? Of course, there are some judgments which have also given some precedence to the right to be heard. For instance, you have cases like Jagdeep Singh versus Ashish Mishra, where the Supreme Court went on to say that, and this is a very sweeping statement that was made by the Supreme Court here, that victims in India have an unbridled right that begins right from the stage of registration of FIR. Unbridled participatory rights. So this is the term that they've used. Technically, this is supposed to include both aspects. This is supposed to include the aspect of the right to be heard, and this is also supposed to include the right to information. But the way then that this statement is coming to be now interpreted by the courts, this has a very limited application. In any case, there's a lot more to say about this, but very little time for us. So I'm going to stay limited in this sense. And the fact is that when it comes to access to justice and fair treatment, um, there is again very little support that is institutionally available to us that is about fructification of a person's right to be treated with compassion and dignity, right? There is very little in our criminal justice system that talks about right to assistance or proper assistance. We're going to see very soon, or even the right to submit some kind of a victim impact statement, right? Um, Take a look at other jurisdictions. Take a look at the UK, Crime Victim Rights Act 2004, or the US Crime Victims Rights Acts of 2004, or the UK Code of Practice for Victims of Crime, and you'll find that there's a day and night difference in which how they have institutionalized victim justice within their framework, and how we are, taking a progressive approach nonetheless, progressive certainly when you compare to the pre 2008 position. Uh, but then it's a very piecemeal approach for us to be working with, right? So we are looking at very small aspects because, again, the law that's developing and the way the law is developing is judge made. So judges can't look at provisions and codes in a very general sweeping manner. They will always be concerned with the enforcement and interpretation of very specific provisions. So they're only able to address very specific issues. So which is why we see that the growth of victim justice in India and victim rights in India, this is something that's happening in a very piecemeal manner, right? Um, in any case, right? So we have, apart from this, two other ways in which which correspond to the four pillars under the Declaration of Basic Principles, right? We'll be taking up compensation and restitution first. So, bright light again here is that India has basically two provisions with respect to compensation and restitution. So we have section 395 of the CRPC, the BNSS, which corresponds to section 357 of the CRPC. and we have section 396 of the BNSS, which corresponds to section 357A of the CRPC, right? Now, 357 is what provides for restitution, or 357 or 395, which this is what provides for restitution. And what this says is that wherever fine is being imposed as a form of punishment, a part of that fine can then be made towards, you know, making good the expenses which have been incurred by the victims of a particular crime, right? So basically, what's happening is that the court imposes a fine on the offender, and then the offender pays that fine, and a part of that fine then goes to the victim. But of course, there were problems with the application of this section, right? And the main problem was that, much like the fact that we don't have any sentencing guidelines, we did not have any guidelines with respect to Section 357 either. So there was no criteria, there was no objective way for the courts to be able to determine what the quantum of compensation, or sorry, the quantum of restitution, that is the quantum of fine that has to be imposed by the court, should be. Right? Forget making that quantum just and equitable, but what should be that amount in the first place? And of course, this idea of what that amount should be is contingent again upon two facts, two very crucial pieces of information that courts in India simply do not have. The first information is what was the impact of the crime upon the victim, right? Remember, we talked about primary victimization and we learned about the impact that the crime has had upon the victim. It's very surprising that the courts very rarely take that into consideration, you know, at the time of imposition of fine, primarily because they never ask the victim, how has the crime actually impacted you in the first place? If they had asked the victim this, of course, they'd get answers. Of course, the victim would be able to quantify the exact losses that he has suffered. He'll be able to quantify the medical expenditures that he has incurred. He'll be able to quantify, for instance, the amount of the property that he lost, the value, for instance, that he would have gained out of it over a period of time. A victim would have been able to do all of that, but the victim was never given this opportunity in the first place, so the court doesn't know. A second crucial piece of element that the courts miss out on in terms of determining what should be the quantum of compensation, is that of the paying capacity of the accused. So the courts simply have no way to determine what the paying capacity of the accused should be. They don't know what are the assets that an accused has or an offender has. They don't know what are the liabilities of that offender. They don't know how many people in his family he has. They don't know what his level of income is. They don't know how propertied he is. They don't know what his outstanding loans are. So without all of this information and without knowing what is the paying capacity of the offender, how is the court supposed to impose a fine, right? Because the BNS and the IPC very clearly tell us that wherever the amount of fine is not specified as a part of the offense, there the court that can impose an unlimited amount of fine, but that amount of fine has to be reasonable. So how do you make it reasonable? You can only make it reasonable by looking at these two factors, by looking at the impact of the crime upon the victim and by looking at what the paying capacity of the offender is. And the fact is that the courts had access to neither of this data. So naturally, Section 357 of the CRPC and Section 395 of the BNSS, they were simply not being utilized, right? So the question is, how do you fix that? So the Delhi High Court, in the case of Karan versus State and City of Delhi, it was, it broke new ground in this area, right? So they formulated a format of a victim impact report so as to identify the impact of the crime upon the victim in order to determine the quantum of compensation after taking into account the gravity of the offense, the severity of the mental and physical harm, and what the damage and the losses suffered by the victim were. Accordingly, they also took into account what is the paying capacity of the offender. Um, Although this judgment only applied to the Delhi NCT of Delhi, the judgment was something that very progressively encapsulated the principle of restitution and compensation through the that was embedded in the UN's declaration. Unfortunately, this judgment in Karan versus State NCT of Delhi has now been overturned by the Supreme Court again, by the Delhi High Court again, in the case of Saif Ali versus State NCT of Delhi. So I've written an opinion piece on this as well. It was published in the Indian Express in February. So if anybody wants access to that, you can always take a look at that. So you'll be able to get more out of it, this entire discussion, right? Of course, another way in which our criminal justice system kind of furthers or you know or brings in this idea of compensation is through Section 397 of the Bharatiya Nyaya Samhita. My my bad. The Section 396 is compensation, is restitution. That is what we understand as restitution through this lecture, and Section 397 is compensation, right? Um, so the BNSS actually requires every single state to prepare a victim compensation scheme in coordination with the central government so as to compensate the victims for their losses as well as their rehabilitation, right? And this is done again by virtue of Section 396 of the BNSS. Um, Apart from this, several specific offenses such as rape of a minor under 16 years of age, you have gang rape, you have acid attack. So all of these offenses also legislatively mandate that that a fine must be levied on the offender and that this fine has to be just and reasonable to meet the medical expenses and the rehabilitation of the victims, right? Um, Now the final aspect of what is the actual position of the criminal justice victims in our criminal justice system and victim rights in our criminal justice system is that of assistance, right? So with respect to this, you have two broad provisions. You have Section 397 of the BNSS, which talks about medical treatment in very specific offenses. Um, if you guys remember, you have you take a look at what is this idea of assistance that's provided for under the UN Declaration, and you'll find that uh, the UN Declaration requires that victims should be given all kinds of medical, material, psychological, and social assistance, right? So you can have different types of assistance itself. So 397 of the BNSS, it imposes a duty on all hospitals to provide free of cost treatment to victims of rape and acid attacks under the Bharatiya Nyaya Samhita of 2023, as well as sexual assault under the POCSO Act. And for all other offences, the District Legal Services Authority has been authorized to order for immediate first aid. Um, and for these benefits of first aid to be provided free of cost to victims upon a production of a certificate, which is from a police officer, not below the rank of an officer in charge of the police station, that is a station house officer or a circle officer, right? Um, However, there are no legislative provisions whatsoever with respect to provision of material assistance, psychological assistance, or physical assistance, or social assistance to victims of crimes under our criminal justice system. Another very important provision in terms of assistance is that of protection of witnesses. And the fact is that as victims are not just primary victims. The primary role that apparently the victims have under our criminal justice system is that they're just evidences. So they're treated often as witnesses rather than victims. But even within this role of them being treated as witnesses, they face several problems, right? They face problems such as that of harassment and intimidation, where the accused families, their associates, they try to pressurize the victim into taking back the complaint or reciling from their testimonies, reciling from their statements. Um, Frequent adjournments, that's a very major institutional issue. Um, as lawyers, we get into a habit of asking for frequent adjournments. And the moment we ask for frequent adjournments, we often end up sending the victim who has traveled all the way to hear what's happening in the case back. This becomes especially problematic whenever the victim themselves have to testify as a witness, right? So that's akin to harassment, but it's institutional harassment. Um, of course, whenever the victim travels then to the courts, and remember that, it's very easy for me to say this sitting in Delhi, where the nearest court is just 2 to 3 kilometers away from where I live. But the fact is that in the hinterlands, it becomes very tough for a litigant to actually be able to travel um, from their village to even the district courts, right? So keep that in mind, right? There's a lot of time that's wasted. There's a lot of energy that goes into this. There's a lot of financial expenditures that happen as well. Um, so in terms of witness protection, however, in the case of Mahindra Chawla versus Union of India, the Supreme Court of India laid down a very extensive witness protection scheme. And this scheme provides for the grant of protection orders. It's a very detailed scheme generally. And it provides for the grant of protection orders, including changing the identity of the victim and the relocation of the victims and the witnesses as well, right? So, as I'm sure that you guys must be able to gauge by now, uh, there's a huge gap between what ought to be and what actually is, right? Um, Now the good thing is that there are certain aspects of our criminal justice system which have progressed uh, in terms of victim rights and provision of victim rights much faster than other areas and general rights of the victims. Uh, which brings me to the next topic of the presentation, which is that of understanding vulnerable victims and the rights of the vulnerable victims, right? Um, so we all know that Article 39A of the Constitution of India, it provides for free legal aid to the poor and the weaker sections of the society. And it wants to ensure the very laudable goal of justice for all. um, Article 14 and Article 22, Clause 1 of the Constitution also make it obligatory on part of the state to ensure equality before law, as well as creating a legal system that benefits and provides for equal opportunity to all. And which is why in the year 1987, the Legal Services Authority Act was created to provide for a free and competent legal service across the country, right? And under that act, you had Section 12, which listed out 8 categories of vulnerable individuals who are eligible for legal aid, right? A member of scheduled caste or scheduled tribes communities automatically qualifies under the DLSL, the Legal Services Authority Act. The victims of human trafficking or a begar, they are referred to under Article 23 of Indian Constitution. Begar, not beggar, begar. Under Article 23 of the Indian Constitution, a woman or a child, they automatically qualify. A person with disability, a victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, and industrial workman, a person who is in custody in a protective home, um, has or somebody who has an annual income of less than 9,000, right? Um, of course, there are problems with this idea uh, because technically, even these 8 categories, they end up encapsulating almost 80% of our population, more or less. And just yesterday, in case you guys are not aware, the India Justice Report of 2025 was released, and you won't believe it, but I learned that the per capita spend of our country on legal services authority is just rupees 6. So we are spending 6 rupees per person on legal services and legal aid under the Legal Services Authority Act, right? You don't get a samosa, you don't get a bag of kurkure now, you don't get a cup of tea now for 6 rupees, but that's how much we are spending now per capita on legal aid. Anyways, so apart from this, you also have the POXO Act, and of course, the POXO Act is one of the more nuanced acts in terms of protecting victims because this is one category of victims which has been very specifically and especially identified as vulnerable. And consequently, apart from the general rights that are available to victims under the criminal justice system that I have just enumerated, under the POXO Act, you have the ideas of identity protection coming in that in order to protect the privacy of victims, Section 23 of the Act lays down the procedure with respect to reporting of such cases by the media. It prohibits the making of any report or presenting any comments by the child in any media platform without verifying first the authenticity of that information. And any information which may have the effect of lowering the reputation of the child or it might end up infringing the privacy of the child, all of these kinds of statements are prohibited. Next, of course, is in terms of recording of statements. So what happens is that under our criminal justice system, a victim has to recount their experiences at multiple stages. First when police officer calls the witness to the victim to the police station. They have to give a statement. Then they have to give a statement before the magistrate. Then they have to again give a statement before the courts whenever the examination and cross examination happens. So that becomes problematic. But the procedure for recording the statement of a child under the POCSO Act, it has been enumerated in Section 24 very clearly. As per the provision, the statement must be recorded at the residence of the child, so they can't be called to a police station. Um, and if practicable, the statement must be recorded by a woman officer not below the rank of a sub inspector. And the recording, whether by a magistrate or the police officers, it must be done in the presence of their parents. So this is to make sure that they are comfortable, right? So you want to create a sense of safety, a sense of security for these victims, because of course you're dealing with children. They don't have the same mental state and level of maturity as adults do, right? Next, of course, is, for instance, preventing contact between the accused and the victim. So one of the most harrowing parts in rape trials, in fact, generally, and cases involving sexual conduct, is that victims and accused are brought face to face, and that creates problems. That creates problems. Why? Uh, because the moment a victim looks at their accused, looks at their um, you know abuser, um, that becomes again a point of torment for them. They might just end up resiling, and they might just end up reverting back to the position where they were when they were actually becoming victimized. So which is why under the POCSO Act, there's a need for us to limit the contact that the victim has with the accused, and which is why um, the officer conducting that investigation under Section 24 subclause 3 has a duty to ensure that the victim never comes into contact with the offender. Similarly, under Section 36, the courts have a duty that the child is never exposed in any way to the accused at the time of recording of evidence, right? At the same time, however, it has to be ensured by the court that the accused also has a right to hear what the victim is saying. So, many jurisdictions have started using something called vulnerable witness deposition complexes. And what these VWDCs do is that they create, or they use either video cameras and video conferencing, or they create two-way mirrors where the victim can't see the accused, but the accused can see the victim and he can hear the victim, right? So you have these ways in which testimonies are recorded these days. Of course, the next point is also with respect to questions. Rape trials have always been very contentious when it comes to questions, because if you put very, it's a strategy of defense for the lawyers that they'll put questions which are demeaning. They'll put questions which um, end up impeaching the character of the victim in such cases, and that is problematic again because that amounts to re-traumatization, that amounts to secondary victimization, and therefore the Section 33 of the POCSO Act says very clearly that the questions which have been put forth by the special public prosecutor or the counsel appearing for the accused, they have to be communicated to the special court, and it's the special court which will then put the questions to the child. So the lawyers, the advocates can never put the questions directly to the child. And at the same time, there are other, during these examinations and cross examinations, there are other remedies that are available and other, ways to make sure that the child is comfortable. For instance, the child is permitted to take frequent breaks. Um, you can't use aggressive questioning, or you should not use questions which assassinate the character of a child. And you have to ensure that dignity of that child is being maintained. And all of this is statutorily required, right? I'm not making this up. All of this is statutorily required, right? Um, of course, you also then have and something called the SCST Prevention of Atrocities Act, and I've kept this for last. I kept this for last for a reason. That this then goes on to answer the third, prong of my question, or of sorry, my presentation, which is that we know what the normative framework looks like. We know what is the position actually, and we know that there's a huge gap between what ought to be and what is. But does our criminal justice system have the potential to reduce this gap? And the fact is that the SCST Prevention of Atrocities Act gives us a direction in this regard, which is why I've kept this for last. And I've also reproduced everything that this section actually says. So you have in Chapter 4A of the SC/ST Prevention of Atrocities Act, which provides for Section 15A. And this 15A, trust me, the way it's worded, it very brilliantly encapsulates everything that I've been saying so far that our system, our criminal justice system in general lacks. Right? For instance, take a look at Section 15(1)(a), which talks about protection for victims. Right? So statutorily incorporated. Section 2 says the victim shall be treated with fairness, with respect and dignity. So this is a statutory duty, right? So this is required by statute. This is required by law that the victim has to be treated with fairness, respect, and dignity. Uh, the victim, the third point says that, the third subsection says that the victim or his dependent shall have a right to reasonable, accurate, and timely notice of any court proceeding. This is something that we still lack. Fifth says that the victim or his dependent shall be entitled to be heard at any proceeding, right? So they have a right to be heard. And they have actually laid out the stages at which, what are the appropriate stages when the victim should have the right to heard. In respect of bail, in respect of discharge, in respect of release, in respect of parole, conviction, or sentence, or any other connected proceedings, and or arguments and file written submissions on conviction, acquittal, or sentencing. Um, the courts themselves have a duty to provide complete protection. The courts have a duty to provide them with traveling and maintenance expenses. They have a right, sorry, they have a duty to ensure the social and economic rehabilitation of the victims during the investigation, inquiry, and trial. They have a right to provide relocation to the victims, right? um, at the same time, there is also a duty to conceal the names and addresses of the witnesses, right? Again, protection. There's a duty to issue directions for non-disclosure of the identity of the victims, to take immediate action in respect of any complaint with respect to harassment of that victim. And it shall be the duty of the investigating officer and the SHO to record the complaint of the victim, informant, or witnesses against any kind of intimidation. Again, then it shall be the duty of the concerned state to specify a scheme to make sure that the following rights are being enforced. First is to provide a copy of the FIR free of cost. Second is to provide immediate relief in cash or kind. Immediate relief, that he must have suffered injury. We are not going to wait for the trial to end. We are going to give them immediate relief in cash or kind to atrocity victims. To provide relief in respect of death or injury or damage to property, to arrange for food, water, or clothing, or shelter, or medical aid, or transport facilities, or daily allowances to victims, assistance. It's one of the weakest links that we have in our criminal justice system in general. But the SC/ST Prevention of Atrocities Act is saying very clearly that the state has to provide for basics: food, water, clothing, shelter, medical aid, transport facilities, daily allowances to the victims. To maintain, to provide maintenance expense to the atrocity victims and their dependents, to provide for information about the rights of atrocity victims at the time of making the complaints, to provide for information to the atrocity victims as to the status of the investigation and to the charge sheet, and to provide a copy of the charge sheet free of cost. Remember, this is something that's being recognized in the Bharatiya Nyaya Samhita now. Um, and supply of all documents can only be made, by the way, under the Bharatiya Nagrik Suraksha Samhita, sorry, uh, after, if the victim has engaged a private advocate, and you already have this in the SC/ST Prevention of Atrocities Act. To provide for information regarding a relief amount, to provide for information in advance about the dates and place of investigation and trial, to give adequate briefing on the case and preparation for the trial. See, you know, we have a victim, in general criminal law, we have a victim's private advocate. That private advocate works under the directions of the prosecutor. But there is no duty on the prosecutor to tell the accused that this is what the case is about, this is how I'm going to brief you, and this is how I'm going to, this is, and then prepare him for the trial, prepare them for the cross examination, prepare for the examination in chief. There's no duty incumbent upon the prosecutor generally to do that. But under the SC/ST Prevention of Atrocities Act, there is, to execute the rights of the atrocity victims at every stage in the proceedings. And it shall be the right of the atrocity victims to take assistance from their NGOs, social workers, or advocates. So the entire purpose of why I have brought this up generally is to tell you that yes, there is potential. There are gaps. There is a huge gap between what ought to be. And what is. But that this gap can be filled. And it's not like our legislative framework does not have guidance in this regard. In fact, our parliament has already legislated on this before. So this is something that we can now do or extend, if not all aspects, then maybe some aspects, uh, just to make sure that we are at least bringing our domestic legislations in conformity with the international standards, right? That is the least that's required in terms of uh, recognition of the rights of the victims. And of course, once you recognize the rights of the victims, their enforcement, that's a whole different ballgame. All right. So with this, I think I'll conclude the lecture for today. Kalpesh sir, do you want to open the floor for questions?
Yes, yes, yes. Now we'll open for question. Participant, you can let me do the setting. So participant, you can unmute and ask or raise hand or put the question in the chat box. Yes, anyone? Question for the boardroom?
Good evening, sir. So there's one question from the boardroom. That is, the needs of a child victim are a lot more in comparison to what a victim who's an adult will have. So how does the criminal justice system accommodate the needs of such child victim?
Okay. So I've already stated what happens with respect to the Protection of Children from Sexual Offences Act, right? But that's a very specific piece of legislation, right? That's only geared towards sexual offences against children. Um, the problem that then emerges is that all of the victims, all of the child victims, they're equated with victims in general, right? So you're absolutely right in pointing this out that there is a inherent deficiency that we seem to think that it's only children who have suffered from some kind of sexual abuse which have then been um, granted certain accommodations in the justice system. But that my point is this exactly, that if we have these kinds of accommodations for victims and vulnerable victims specifically, then why can't we have these kinds of accommodations in the law for all victims in general? And then you won't need to have any special categories as such. And that is something very basic that's expected from the criminal justice system as well. Now, of course, when you're dealing with sexual offenses, some things become very, crucial to sexual offenses themselves. For instance, the right to have an in-camera trial, right? So the general rule is that we are supposed to have proceedings which are open to the public, right? But in-camera trials are required for rape cases and sexual assault cases and sexual offenses, precisely because at the end of the day, that's a very sensitive matter, and that is something that requires, in fact, the non, disclosure of the identity of the victims and the witnesses. So therefore, it's imperative that you have in-camera trials. So of course, you can have specific procedures with respect which are tailored to the specific needs of the offense of the victims, but at the same time, there's a definite requirement for us to extend various other protections to all victims in general so that we can address the situations which have been pointed out by you very specifically, right? That's a good question.
Thank you, sir. There's another question in the chat box. So Ms. Mamta is asking which books can we refer to know more about the victim rights?
Okay, so on the Indian jurisdiction there is a book by Shriya Gauba and Professor G.S. Bajpai. So that's a great resource, right? Victims, I think it's called Victims in the Indian Criminal Justice System. So you can take a look at that. I've typed out their name in the text box. Apart from this, there is a manual that NLU Delhi had developed. It's called somewhere along the lines of securing duties of frontline professionals. I'm typing this out again on the chat. This for victims of, yeah, so it's called Duties of Frontline Professionals Towards Securing Justice for Victims of Crime. So you can take a look at this as well. And this is always going to, this is a mix of both normative requirements as well as the what actually is. And in fact, what I'll do is I'll maybe post the link here as well. Yeah, so this is for all to see. Then this is an open resource.
Thank you, sir. Another question is how does plea bargaining affect victim rights?
Okay, so that's again a good question. Now, see, plea bargaining was always meant to be a source of diversion. Like, so the idea there was that, uh, look, we are dealing with, so many offenses. Our justice system is already overburdened. Our prisons are already overcrowded. Is there a way for us to divert offenders away from the criminal justice system, right? I'm bringing this point upfront because I want to make it clear that plea bargaining was never supposed to be a system that was focused on the victims to begin with. It was only meant at resolving the problems that our criminal justice system is facing, right? Victims were never at the center of it. It almost seems like an afterthought that, uh, that victims were actually given the right to say no to a plea bargaining, right? That, of course, victim is a party to the system, so therefore the victim must have the right to either agree to a plea bargaining, proceeding, or say no to a plea bargaining proceeding. But that seems like something that you thought of after you decided that you're going to put in plea bargaining as a system in the criminal justice system, right? Um, so what that does essentially is that again it disentitles victims to a very large extent, right? And it does a huge disservice to the victims generally as well, because at the end of the day, if you want to forward plea bargaining as some kind of a restorative justice mechanism, uh, plea bargaining is just one kind of a restorative justice mechanism. There's a lot more to plea bargaining than to restorative justice than just plea bargaining. So you should have brought in plea bargaining as a measure that complements other measures, right? Rather than being the sole measure that you have in the Indian criminal justice system. So I would like to say that there's not much that plea bargaining does. Another reason that plea bargaining doesn't do much is that it's not being invoked very frequently at all, right? I think it's got a lot to do with lawyers themselves not being very, in favor of resorting to plea bargaining mechanisms, primarily because again that's a loss of bread and butter for them, right? So of course there's a need for us to fix this in mechanism in that sense as well. Yeah.
Thank you, sir.
Okay.
Do the participants have any other questions?
Okay, any last question, participants? No question. Over to boardroom.
Thank you, sir, for this informative session. I would now like to hand over to Vibha for the voting. Good evening, everyone. It is my privilege to deliver the vote of thanks on this important session on human rights and the rights of the victim. First and foremost, I extend our sincere gratitude to Mr. Ankit Kaushik for his insightful and thought-provoking talk. Your words have not only deepened our understanding of human rights, but also remind us of the critical needs to uphold the dignity and rights of the victim in all circumstances. Your experience and perspective have truly enlightened us. And I would also like to thank Mr. Kalpesh Kumar Gupta, who is a backbone of this program, and Ms. Asmatunisa for the efforts in making this session possible, and Mr. Nagendra Murthy for his presence. I also want to thank our participants for your presence and making this session impactful. Let us carry forward the spirits of today's discussion in promoting justice, equity in our communities. Once again, thank you all, and especially Mr. Ankit Kaushik for making this session so meaningful.
Thank you.
Okay.
Thank you
Thank
very
you
much.
so much.
Thank
It's been a
you.
pleasure.
Thank you. Thank you. Thank you.
Yeah.